Good morning, online students. So the next topic is doctrine of basic structure. It's a slightly long topic and probably the most important topic to be discussed under the whole constitution, and it defines the constitution. It's the most important milestone that the constitution has reached in its evolution, continued evolution. So much so that the Chief Justice of India called the basic structure as the North Star of the Indian Constitution or guiding star of the Indian Constitution. It guides how the Constitution should be interpreted and applied. So such is the importance of this basic structure. I will go a little slow, write down the things as much as possible on the board, understand, and also take your running notes. Fundamental rights. Yes, the fundamental rights topic is going on. I will take about another 4 or 5 classes. So basic structure is part of the fundamental rights topic. Right. Now we have seen many times what is Article 368. Article 368 tells about how to bring about an amendment to the Constitution. Under Article 368, a constitutional amendment bill can be introduced in either house of the Parliament, and if it is passed with a 2/3 majority and on getting the assent of the President, it becomes a constitutional amendment act. So therefore, Article 368 clearly says that the Constitution can be subjected to amendment by the Parliament. And in the previous class, we had also seen Article 13, Clause 2, when we discussed the judicial review. And Article 13, Clause 2 says, the state shall not pass any law that takes away or abridges one or more fundamental rights. If any such law is passed, the law is unconstitutional and void. Or in other words, that Article 13, Clause 2 tells that no law can amend the fundamental rights. If any such law is made, the law is unconstitutional. Whereas Article 368 says that any part of the Constitution can be amended by the Parliament, and no exception is given to the fundamental rights, and fundamental rights can also be amended under Article 368. Whereas Article 13, Clause 2 says the fundamental rights cannot be changed by a law passed by the state. Is there any contradiction between these two articles? Which is true? Well, the issue began right after the Constitution entered into force, and many state legislatures, they enacted what was known as the Zamindari Abolition Act, officially known as the Land Reform Acts. And under these Land Reform Acts, the excess land held by the zamindars were taken over by the state governments, and the land was distributed among the landless poor. So that was the essence of the Land Reform Acts. And the Land Reform Acts were challenged before the Supreme Court as unconstitutional and void in a case known as Kameshwar Prasad was the state of Bihar. So in this case, the Land Reform Acts were challenged before the Supreme Court on the ground. The Land Reform Acts, they violated the fundamental rights given under Articles 14. So you know what is Article 14? Article 14 talks about right to equality. So it was argued the Land Reform Acts, they took over the lands of only one section of the landlords, and because of this, that it violated their right to equality. Not everybody's land was taken over, but only the rich landlords' properties were taken over. Thus their right to equality was violated. It was also argued that the Land Reform Acts violated Article 19 and 31 also, because 19 and 31 during those days conferred the right to property as a fundamental right. So the right to the property and the right to equality were violated by the Land Reform Acts, and because of this, as per Article 13 Clause 2, the Land Reform Acts were argued to be unconstitutional and void. And the Supreme Court in the Kameshwar Prasad case accepted this line of argument and held the Land Reform Act as unconstitutional and void. So the Land Reform Acts were held to be unconstitutional and void on the ground that they violated Article 14, 19 and 31, and as per Article 13 Clause 2, the Land Reform Acts were unconstitutional and void. Similarly, the government of Madras introduced a reservation policy. So it was a policy to reserve seats for the backward classes of citizens in higher educational institutions. So under this reservation policy, the government of Madras became the first government in India to reserve seats for the backward classes of citizens in educational institutions. And this reservation policy was challenged before the Supreme Court in a case known as State of Madras versus Dorai Rajan. So in this case, it was argued before the Supreme Court that the reservation policy violated the fundamental rights under Articles 14 and 15. It affected the rights of the upper caste, and thus it violated the right to equality. It favored the backward classes and it discriminated against the upper caste. So it was violative of the right to equality. Second, Article 15 says caste cannot be the only consideration on which discrimination can be made. And reservation policy, the discrimination was made in favor of the backward classes only on the basis of caste. Therefore, these two fundamental rights were violated, and as per Article 13 Clause 2, the reservation policy was unconstitutional and void. The Supreme Court in this case also held the reservation policy of the government of Madras as unconstitutional and void as per Article 13 Clause 2. So thus two major progressive legislations were held to be unconstitutional and void by applying Article 13 Clause 2 of the Constitution. So now there was a hue and cry, and it was suggested the Constitution was being applied to benefit the zamindars and ignore the interest of the landless poor. Constitution was applied to sustain the interest of the upper caste and ignore the interest of the lower caste. The government felt that there was some deficiency in the constitution, and to fill up that deficiency, because of these two decisions, the parliament passed the first Constitutional Amendment Act in 1951. In exercise of its power under Article 368, so under Article 368, that the Parliament passed this First Amendment Act. So in this case, the state of Bihar was the respondent. In this case, the state of Madras was the petitioner. Why? Because this reservation policy was first challenged before the High Court of Madras. And in that, Dorai Rajan was the petitioner, state of Madras was the respondent. And the High Court of Madras held the reservation policy as unconstitutional and void. So against the High Court's decision, the state of Madras went to the Supreme Court, therefore it became the petitioner. So you should note the difference. Is it clear or not? If you file a petition against Vajiram and Ravi in a court of law, whose name appears first? Who is the petitioner? Who is the respondent? You are the petitioner and Vajiram is the respondent. So the Vajiram name appears later. In this case, that Dorai Rajan was the petitioner who filed a case against the government of Madras in the High Court of Madras. And the High Court of Madras held this reservation policy as unconstitutional and void. And against the decision of the High Court, the state of Madras went to the Supreme Court as the petitioner and filed an appeal against the Dorai Rajan. So that is why that the names are reversed. Is it clear now or not? Okay. Right. So what did the First Amendment Act do? First of all, it added Article 15, Clause 4. Clause 4 was added to Article 15. It also added Article 31A. Article 31B and 9th schedule to the Constitution. So these were some of the changes made by the First Amendment Act. Article 15, Clause 4, it conferred the power on the state. We will see Article 15, Clause 4 more in detail when I take up Article 15 in the next class. But for the time being, that Article 15, Clause 4 conferred the power upon the state, the government, to make special provisions in favor of the backward classes of citizens, including scheduled caste and scheduled tribe. The original constitution did not confer the power on the parliament, on the state, to make special provisions like reservation of seats for the backward classes of citizens. And since the court held reservation policy as unconstitutional, to overcome this problem, that Article 15, Clause 4 now confers the power on the state to make special favors to the backward classes of citizens. And Article 31A in a way the diluted right to property. Article 31A says if the state enacts any law providing for taking over of private property like estates, jagirs, inams, etc. And if the bill passed by the state legislature is reserved for the consideration of the president, and on getting the assent of the president, if it becomes a law, then the law cannot be challenged before a court of law. If any state government passes a bill providing for taking over of agricultural lands, and if the bill is reserved for the consideration of the president and on getting his assent, if it becomes an act, a law, that law cannot be challenged before a court of law. Or in other words, this kind of land reform acts, if they become acts by getting the assent of the president, they cannot be challenged before a court. Only when the law is challenged before the court, you can declare it as unconstitutional and void. If it cannot be challenged before a court, you cannot declare it as unconstitutional and void. Then Article 31B, it says, any such law made providing for taking over of the property, if it is placed under the 9th schedule to the Constitution, the law cannot be challenged before a court of law. Article 31B says, any law that is placed under the 9th schedule to the Constitution cannot be challenged before a court of law. So, if the land reform acts are all placed under the 9th schedule to the Constitution, the land reform acts cannot be challenged before a court of law. So, these were the changes made by the First Amendment Act, a kind of protection given for the land reform acts. And the First Amendment Act was challenged before the Supreme Court in a case known as Shankari Prasad versus Union of India, 1951. So, in this case, it was argued the First Amendment Act violated Article 14, the right to equality. It violated Article 19 and 31 of the Constitution. Article 14, Article 15 also. Article 14, Article 15, 19 and 31. These fundamental rights were affected by the First Amendment Act. Therefore, First Amendment Act was unconstitutional and void. That was the argument placed before the Supreme Court in the Shankari Prasad case. Now, what was the decision of the court? In Shankari Prasad case, the Supreme Court stated that under the Constitution, the Parliament enjoys two types of legislative power. One is known as the constituent legislative power. Under Article 368. So, the Parliament enjoys two types of law-making power. Legislative power means law-making power. The first type of law-making power is constituent legislative power given under Article 368. The second is ordinary legislative power outside Article 368. So, the Parliament can make two types of laws. The one type of law is made under Article 368, which is called constituent legislative power, and the other is the ordinary law, which is made under articles outside Article 368. This constituent legislative power is the creative power of the Parliament, comparable to the power enjoyed by the Constituent Assembly of India, with which the Assembly was able to enact the entire Constitution. And further, under Article 368, this constituent legislative power is exercised with what kind of majority? Special majority, whereas this ordinary legislative power is exercised by the Parliament with simple majority. So, this is the difference between the two. For example, what is Article 3? that is the Article 3 says that any change in the name, area or boundary of a state can be brought about by the Parliament by enacting a law. Or in other words, under Article 3, the Parliament has law-making power with regard to the change of name, area or boundary of a state. So outside Article 368, the Parliament has law-making power, which is ordinary legislative power. What is Article 11? The Parliament can regulate the citizenship in India. And thus under Article 11, the Parliament enacted Indian Citizenship Act 1955. So therefore under Article 11, the Parliament has ordinary legislative power under which that it can regulate the citizenship rights in India. So likewise, there are many such articles outside Article 368 under which the Parliament enjoys legislative power, and those legislative powers are ordinary legislative powers exercised with a simple majority. Now further, the Supreme Court in this case stated that any enactment made by the Parliament under Article 368 is called a constitutional amendment. So the court also clarified that any enactment made by the Parliament under Article 368 is called a Constitutional Amendment Act. And what is the name given to the ordinary legislation made by the Parliament? And any enactment made outside Article 368 by the Parliament made under outside Article 368 is called statutory law. So any enactment made by the Parliament outside Article 368 is called statutory law. So that's the difference between these two. So it clarified these two. Then further, thereafter that the Supreme Court proceeded to understand what is the meaning of the expression law as given under Article 13 Clause 2. What does Article 13 Clause 2 say? It says the state shall not make any law that takes away or abridges one or more fundamental rights. And such a law will be declared as unconstitutional and void. And in general, law means what? Anything that is legally enforceable is law. It may be an ordinance, it may be anything that is legal. So we should understand what is the exact meaning of the expression law. Because what is the nature of Article 13 Clause 2? The nature of Article 13 Clause 2 is prohibiting. Why? Because it prohibits the government from amending the fundamental rights. Now, is Article 13 Clause 2 prohibitive in total or partial? Is the prohibition imposed under Article 13 Clause 2 is partial or total? For that purpose, the judiciary started examining what is the meaning of the expression law as given under Article 13 Clause 2. And the court concluded that the expression law includes. So the expression law as given under Article 13 Clause 2 includes number 1, statutory law. Statutory laws, ordinances, bylaws, personal laws. Rules, regulations, notifications, orders, directions, etc. framed by the government. So, the expression law includes all these things. And the expression law does not include a constitutional amendment act. So the court clarified the law includes all these kinds of laws, but the expression law does not include a constitutional amendment act. What is the logic behind this? What is common among all these things? They are simple legislations. They are made with simple majority or by the government. Whereas Constitutional Amendment Act is made with special majority. Therefore, the court stated what Article 13 Clause 2 prohibits is this kind of laws from amending the fundamental rights. And the expression law under Article 13 Clause 2 does not include a constitutional amendment because Article 368 has been created by the Constitution to amend the Constitution. So therefore, the court stated that Article 13 Clause 2 prohibits only this kind of legislations, ordinary legislations, which cannot amend the fundamental rights and thus the Constitution. But the Parliament can amend the Constitution under Article 368. And on the basis of this, the Supreme Court held the first Constitutional Amendment Act as constitutionally valid. The court stated, yes, the Parliament under Article 368 can amend any part of the Constitution including the fundamental rights. What is prohibited under Article 13 Clause 2 is simple legislation. Ordinary power legislation cannot amend the fundamental rights. Special legislation with special majority can amend. Was the Supreme Court right in holding the Land Reform Acts as unconstitutional and void? Was it right or wrong? How would you examine it? What is the nature of this Land Reform Act? Was it made with simple legislative power or special legislative power? So therefore the Supreme Court was right in holding the Land Reform Acts as unconstitutional and void because it was passed with a simple majority. Reservation policy, it was a policy formulated by the executive, which comes under rules, regulations, notification. So therefore that the court was earlier also correct and in Shankari Prasad case also it was correct in holding the first Constitutional Amendment Act as constitutionally valid. So is this point clear? Right. Subsequently, the Parliament passed the 4th Constitutional Amendment Act and also the 16th Constitutional Amendment Act, which both of them, they further diluted Articles 19 and 31. So the right to property was further amended. And these two amendment acts were challenged before the Supreme Court in a case known as Sajjan Singh versus State of Rajasthan, 1965. And in this case, the Supreme Court held both these acts as unconstitutionally valid. So by following the same line of interpretation given under Shankari Prasad, the court in the Sajjan Singh case also held these two amendments as valid. Then in the Parliament passed the 17th Constitutional Amendment Act in 1964, which once more amended Articles 19 and 31. So the right to property was successively diluted in terms of paying compensation, in terms of taking over of the property, etc. And by the time when the 17th Amendment Act was passed, in state of Madras versus Dorairajan, no reservation can be made because there was no provision in the constitution. Right. So, by the time when the 17th Amendment Act was passed, a kind of sharp differences had arisen between the Supreme Court and the Parliament. The Supreme Court felt that the right to property was diluted way beyond its original shape, and it was too frequently amended by the Parliament. That was the view that the Supreme Court had adopted. Whereas the Parliament felt that the right to property came in the way of enacting progressive legislations like Land Reform Acts, reservations, etc., and it has to be suitably amended. And the 17th Amendment Act was challenged before the Supreme Court in Golaknath versus State of Punjab, 1967. And the differences between the Supreme Court and the Parliament over the right to property got reflected in the decision made in the Golaknath case. Now, you all know only a larger bench of the Supreme Court can overrule its decision of a smaller bench. The Shankari Prasad case was decided by a bench consisting of 5 judges. Sajan Singh case was decided by a bench consisting of 9 judges. And Golaknath case thus was decided by a bench consisting of 11 judges, so that if the Golaknath case were to overrule the Sajan Singh case decision, it will be able to do with the larger bench. Now, what were the decisions of the Supreme Court in the Golaknath case? First of all, it overruled its earlier decisions prospectively. So it overruled Shankari Prasad and Sajan Singh case decision. It set aside the. And what is prospectively, which means up to 16th Amendment Act, the acts will be valid. But any amendment made after 16th Amendment Act will be invalid. Why? Because under the First Amendment, 4th and 16th Amendment, thousands and thousands of acres of property had been acquired by the state governments. They had been distributed among the landless poor, and they would have sold it to somebody. So because of this, if it is the law had been declared retrospectively as invalid, then it would have created a lot of confusion in the country. So because of this, up to 16th Amendment Act, that whatever amendments that had been done and the lands that were taken over, they will be valid. But after 16th Amendment Act, that the law will be invalid. Then on the basis of this, it held the 17th Constitutional Amendment Act as unconstitutional and void. Second decision, the 17th Amendment was held to be unconstitutional and void. Then third, the court refused to acknowledge refused to acknowledge that the Parliament enjoyed constituent legislative power under Article 368. It refused to recognize that Article 368 conferred constituent legislative power. Why? In Shankari Prasad and Sajjan Singh case, the court stated that Article 368 conferred constituent legislative power. You enjoy two types of legislative power, I agree. But in the Golaknath case, the court stated no. Article 368 does not confer constituent legislative power. And the court stated the Parliament enjoyed only one type of legislative power, that is called ordinary legislative power, no constituent legislative power. Why? The reason given by the Golaknath case decision was the title of Article 368 as found at that time was procedure to amend the Constitution. The title of Article 368 was procedure to amend the Constitution, and Article 368 nowhere stated that power of the Parliament to amend the Constitution. The Article 368 did not include the word power. So the Article 368 did not say power of the Parliament to amend the Constitution, but Article 368 merely stated procedure to amend the Constitution. Therefore, the Supreme Court in the Golaknath case stated, look, it gives you only the procedure, it doesn't confer power on you to amend the Constitution. Whereas in the Shankari Prasad and Sajjan Singh case, that the court felt that this power to amend the Constitution was implicit under Article 368. For example, if the constitutional makers did not want the Parliament to amend the Constitution, why should they include the procedure in such great detail? The very fact that the procedure to amend the Constitution had been given in such great detail was suggestive of the fact that if the Parliament were to amend the Constitution tomorrow, this is the procedure to be followed. So therefore, in the earlier two decisions, Shankari Prasad and Sajjan Singh, the court held the power of the Parliament to amend the Constitution was implicit under Article 368. Whereas in Golaknath case, the Supreme Court took a very narrow grammatical interpretation of the Article 368 and refused to accept that it conferred the constituent legislative power. Then further, the court also held the Constitution has given a transcendental or overriding position to the fundamental rights. So that the Constitution had conferred an overriding or transcendental power on the fundamental rights. So what do you mean by overriding power? If there is any clash between fundamental rights and other provisions of the Constitution, in such a case, the fundamental rights will override the other constitutional provisions. So because of this, the court held fundamental rights cannot be amended. No authority functioning under the Constitution, including the Parliament, can amend the fundamental rights. And when the court was asked, then how can we amend the fundamental rights? The court stated only by reconstituting the dissolved Constituent Assembly, you can amend the fundamental rights. So my lords, that all the members of the Constituent Assembly had gone to their heavenly abode, what can we do? You can't do anything. So it was such a backward looking decision of the Supreme Court. The Supreme Court could not resolve the differences that it had with the Parliament with a balanced decision. And it was poorly reflected. And this was the decision of the Supreme Court in the Golaknath case. As a result of this, in the 1971 midterm elections held to the Lok Sabha, Indira Gandhi returned back with a thumping majority. And the parliament responded to the Golaknath case decision by enacting this 24th Constitutional Amendment Act 1971. So the Parliament enacted the 24th Constitutional Amendment Act 1971, which was in direct response to the Golaknath case decision of the Supreme Court. What did this act say? The first, it changed the title of Article 368. It amended the title. Now, if you look at Article 368 today, the title reads as Power of the Parliament to amend the Constitution and the procedure therefore. So now Article 368 clearly says that the Parliament enjoys the constituent legislative power. So before 1971, the constituent legislative power of the Parliament was implicit under Article 368. But after 24th Amendment Act, it has been made explicit. Then second, it added Article 13 Clause 4. It added Article 13 Clause 4. What does Article 13 Clause 4 say? It says, nothing in this article shall include a Constitutional Amendment Act. Nothing in Article 13. So Article 13 Clause 4 says, nothing in Article 13 shall include a constitutional amendment. Nothing in Article 13 shall include a constitutional amendment made under Article 368. Or in other words, what it means is a constitutional amendment act does not come within the meaning of the expression law as found under Article 13. So if this says, what is Article 13? The primary purpose of Article 13 is to find out the meaning of the expression law. So nothing in Article 13 shall include, that is the expression law in Article 13 shall not include a Constitutional Amendment Act. So if you look at these two things, they are not new. Originally they were judicial decisions. These were the decisions of the Supreme Court in Shankari Prasad and Sajjan Singh case. The 24th Amendment Act made the judicial decision into a constitutional provision, that's all. And the 24th Amendment Act was challenged before the Supreme Court in a case known as Keshavananda Bharati versus State of Kerala, 1973. And it was decided by a bench consisting of 13 judges. If it were to overrule the Golaknath case decision, it must have a larger bench. So this is the only case that has been decided by the Supreme Court with a bench as large as 13 judges so far. Now what were the major decisions of the court in this case? The first is, it overruled its earlier decision in Golaknath case. It's overruled the Golaknath case decision. Overrule means it set aside the Golaknath case decision. Then second, It held the 24th Amendment Act as constitutionally valid. It held the 24th Amendment Act as constitutionally valid. Then third, it acknowledged that the Parliament enjoyed constituent legislative power under Article 368. So it agreed, the Supreme Court agreed, the Parliament enjoyed constituent legislative power under Article 368. That it enjoyed the constituent legislative power under Article 368, with which it can amend any part of the Constitution. With which the Parliament can amend any part of the Constitution, including the fundamental rights. Including the fundamental rights. Right. Now, fourth decision, which is the most important decision. The fourth decision, however, such an amending power of the Parliament, is not unlimited. Such an amending power of the Parliament is not unlimited, but it is limited. To the extent of not destroying the basic structure of the Constitution. Is limited to the extent of not destroying the basic structure of the Constitution. So this decision was very balanced one. After the 24th Amendment Act, what was the decision of the Supreme Court in the Golaknath case? No amendments. And what was 24th Amendment Act stated? Power to amend. So these were the two extreme views taken by the Supreme Court at the end of the Golaknath case decision and at the end of the 24th Amendment Act. Two diametrically opposite decisions. And the Supreme Court in the Kashwandi Bharati case found an excellent balance between these two stands. It agreed with the Parliament. Yes, you have the power to amend the Constitution. Agreed. But this power is not unlimited, it is limited. You amend to the extent that you don't destroy the basic structure. So it incorporated the spirit of the Supreme Court decision in the Golaknath case and at the same time acceded to the Parliament's assertion that it had the power to amend the Constitution. Right. Now the next is, what is basic structure? The Supreme Court has not defined what is basic structure even today. But we can define basic structure as, basic structure means those provisions of the Constitution without which the Constitution would lose its basic character. For example, that if the democracy is amended and diluted, then the Indian constitution would resemble more of the North Korean constitution, not the original Indian constitution. If secularism is damaged, the Indian constitution would look more like a theocratic state like Saudi Arabia, Iran, etc. So that is what is known as basic structure. And the Supreme Court stated the constitution stands on certain values, where these values act as the pillars. So like how this building stands on certain pillars, in the same way, the constitution also stands on certain values of those values which are the pillars. If you destroy the pillars of this building, you are not only destroying the pillars, but you bring down the entire structure. But if you damage the walls and the floors, you don't destroy the building. Likewise, the constitution has basic structures and complementary parts. So the constitution actually has two types of provisions. The one is known as the basic structure, the other is known as the complementary structure. You amend the complementary parts of the constitution the way you like, I don't mind. But you cannot destroy the pillars of the constitution. That's what the court stated. Even though the court has not the defined basic structure, in a number of cases, starting from the Keshavanandi Bharati case, the Supreme Court has identified many provisions of the constitution which are parts of the basic structure. What are they? So these provisions have been identified by the Supreme Court in various cases. 1. Supremacy of the Constitution. Supremacy of the Constitution. You cannot compromise on that. Then second, sovereignty of the country. Sovereignty of India. Then third, mandate to build a welfare state. The mandate to build a welfare state provided in Part 4 of the Constitution. Then 4, secularism. 5, democracy. Then 6, republican form of government. Republican form of government. Then 7, parliamentary form of government. Parliamentary form of government. Free and fair elections in the country. Free and fair elections in the country. Then rule of law. Judicial review. Independence of judiciary. independence of judiciary. Then fundamental rights given under Articles 14, 15, 19 and 21. So only fundamental rights given under these 4 articles are parts of the basic structure. For example, right to property was not included as part of the basic structure. Then balance between part 3 and part 4. Federalism. Separation of powers. Balance among the 3 organs of the state. So these are some of the provisions which have already been identified by the Supreme Court, not in a single case, but in a number of cases. For example, in Indira Gandhi versus Rajnarayan 1975 case, free and fair elections were recognized as part of the basic structure. In Minerva Mills case, balance among the 3 organs of the state were held to be part of the constitution, of the basic structure, right. Now in this you could see something is missing. What is it? Is preamble a part of the basic structure? As per the Supreme Court decision so far, no. So preamble per se is not a part of the basic structure. But the values of the constitution that are incorporated in the preamble, they are parts of the basic structure. Sovereign, socialist, secular, democratic republic. So a preamble as such is not a part of the basic structure. Right. So thus it was thought that the parliament was given sufficient power to amend the constitution but not overwhelming power to destroy the constitution. So then the next development with regard to this basic structure, it came up during the national emergency days. So 2 more classes were added to Article 368. So why did the Supreme Court did not add preamble in the list of basic structure? Because a constitution need not have to have a preamble. The Government of India Act 1935, which was our previous constitution, did not have a preamble. So the preamble is not even an essential part of the constitution, let alone it is the basic structure. Even if the preamble is removed from the constitution would continue to function as if nothing has happened. So therefore, the values that are included, values of the constitution that are included in the preamble, they are values not because they are stated by preamble. They are otherwise found in the various provisions of the constitution. For example, which article of the constitution provides you the secularism? It's Article 27. It's not preamble that gives you secularism. Preamble only says what the constitution has already included secularism under Article 27. Right. Right, what are these provisions? What does it say or what it said? So it said that a constitutional amendment act cannot be challenged before a court of law. A constitutional amendment act cannot be challenged before a court of law. You can't challenge the constitutional amendment before a court of law. Only when you challenge it, it can be declared as unconstitutional and void. And what does it mean? It means no judicial review for the courts. If the constitutional amendment cannot be challenged, it means no judicial review for the courts. Then Article 368, Clause 5. What did it say? It said that there shall be no limitation whatsoever. So Article 368, Clause 5 stated, there shall be no limitation whatsoever on the amending power of the Parliament. There shall be no limitation whatsoever on the amending power of the Parliament. So the Parliament tried to give itself unlimited powers to amend the Constitution. In Kashwan Bharati case, the court stated the amending power is limited, but the Parliament asserted no, it is unlimited. What is the net result? It disturbs the balance among the executive, legislature and judiciary. For example, the separation of powers leads to the emergence of executive, legislature and judiciary, the three wings. And a balance must be maintained among them. None of them should be superior to the other two. But if the legislature is given unlimited power to amend the Constitution, what the legislature can do, it can gradually erode the powers of the judiciary and increase its own powers. And thus that it will disturb the balance among the three organs of the government. That is the net result. Right. And these two provisions were challenged before the Supreme Court in the Minerva Mills case. So this clause 4 and 5 of Article 368 were challenged before the Supreme Court in the Minerva Mills case, and in this case the Supreme Court held them to be unconstitutional and void. So the court held Article 368 clause 4 and 5 as unconstitutional and void on the ground that they destroyed the basic structure of the Constitution. On the ground that they destroyed the basic structure of the Constitution by taking away the power of judicial review, on the ground that they destroyed the basic structure of the Constitution by taking away the power of judicial review, and disturbing the balance among the three organs of the government. And disturbing the balance among the three organs of the government. So thus from 1980 onwards, there is now a well-established balance between the Parliament's power to amend the Constitution and the need to sustain the original character of the Constitution. Now the doctrine of basic structure has come to stay, and it is through this, as I said, that it is the prism through which now we look at the constitution, interpret it and apply. So that is it, like how the pole star guides the navigation. In the same way, the basic structure guides the application and progression of the constitution. That's it. And if you look at the Kashwandi Bharati case, it is so important. It was an innovation of the Indian judiciary, and it has been quoted by various other Supreme Courts outside the country. And it was just a bit of luck for the country, how we decided. Of these 13 judges who sat and decided the Kashwananda Bharati case, 6 judges were the judges who sat in the Golaknath case also. They were called the old gods. And 6 other judges appointed by Indira Gandhi after the Golaknath case decision, they were called the new gods. These 6 judges, they held on to the old view that the parliament did not have the constituent legislative power, no power at all. Whereas these 6 judges, they held to the view that parliament has the power to amend the constitution and the parliament enjoyed constituent legislative power. So a kind of deadlock. And it was Justice H.R. Khanna, Hansraj Khanna, who joined hands with these judges, and the decision of the court became 7-6. And the majority decision was the parliament can amend any part of the constitution, including the fundamental rights under Article 368. Once this question was settled, the bench had to decide on the second issue. Okay, what is the nature of such an amending power of the parliament? On that second question, these 6 judges, they held that the power of the parliament to amend the constitution was limited. Whereas these 6 judges, they held the power of the parliament to amend the constitution was unlimited. So while deciding on the second question, Justice Khanna, he switched sides and joined hands with these judges. And again that the decision became 7-6, that such an amending power of the parliament is not unlimited. It is limited to the extent of not destroying the basic structure. So it is one judge, H.R. Khanna, who brought in so much of balance, which has now come to be seen as the majority decision of the Supreme Court in the Kashwandi Bharati case. And what did he get for this kind of fine balance that he could provide? He was superseded by Indira Gandhi when his turn came to be appointed as the next Chief Justice of India. And he is acclaimed for the contributions that he has made for maintaining the stability of the constitution. And did we discuss this habeas corpus case? There also that H.R. Khanna played a crucial role. That ADM Jabalpur versus, yes, that is the habeas corpus case. In that also he gave a very innovative interpretation to right to life. So for these 2 reasons that he is remembered today. And his nephew is going to become the next Chief Justice of India in August 2024, Sanjay Khanna. Right, any doubts relating to basic structure? Shall we move on to the next topic? So part of the basic structure cannot be destroyed, it can be amended, but it should not be destroyed. I know that this basic structure topic is little heavy, and you could have taken at least a major part of the notes. Go home, listen to the recorded lecture once more, fill up the gaps, revise it once, twice, and if you have any more doubts, that we can deal with it in the very next class when I meet you. Yes?
legislature passed Article 368, Provision 4, Clause 4, claiming that the no constitutional amendment act can be challenged
before a court of law.
before the court of law. Was it enforced before the very constitutional amendment act was challenged?
No, the constitutional scheme is that the court enjoys judicial review. It can review any of the decisions of the executive and the legislature. It is one thing that the legislature asserts that its decisions cannot be reviewed by the Supreme Court.
But its powers was clipped after this was passed.
Which one?
After 368 4 was passed, the powers of the judiciary would have been clipped. Then how did it?
No. But it is not final. Any decision made by the state is subject to review by the court. So that I am a teacher and I will finally decide. You say no, you cannot decide. I will decide. Your decision, your stand is subject to my review. The parliament can say many things. But whatever that it says under the constitution is subject to review by the court. Yes? No, that the court will specify whether it is prospective or retrospective. Yes. Yeah, that it's a good question. He says that if the court holds something as unconstitutional and wrong, how the parliament subsequently can pass a law on the same issue. For example, that why this reservation policy in state of Madras versus Dorai Rajan case was held to be unconstitutional and void by the Supreme Court. The court stated you don't have power. There is no provision in the Indian constitution which conferred power on you to make reservation for backward classes of citizens. Therefore, your reservation policy is wrong. And then what the parliament did? It introduced Article 15 Clause 4. And Article 15 Clause 4 confers the power on the state to make special provisions in favor of backward classes of citizens. If the Supreme Court points out a deficiency in a law based upon which that it says it is wrong, the parliament subsequently can amend the constitution to fill up the deficiency. So in this case, okay, you say I don't have power to make provisions for reservation. All right, now the constitution gives me the power under Article 15 Clause 4. So now what happens is Article 15 Clause 4 becomes subject to judicial review. And it is for the Supreme Court to decide whether it is constitutionally valid or not. And in Shankari Prasad case, it said it is valid. So that is how after the addition of Article 15 Clause 4, reservation of seats are allowed to be made in favor of backward classes of citizens in educational institutions. So this kind of change can be made. Right. So then shall we go to the next topic? So yes, now Noor, that the question is that Article 368, Clause 4 and Clause 5 were held to be unconstitutional and void by the Supreme Court in the Minerva Mills case. Then how come they continue to be in the Constitution? Who is the authority to change the Constitution? Parliament. So if at all, if these two provisions are to be removed, the Parliament can only remove. and they have been declared as unconstitutional and void by the Supreme Court, which means they are no longer legally valid. They are called dead wood in a living tree. So they remain there as a dead wood in a living constitution. They are not valid, they are not enforceable. That's the meaning. If at all they are to be removed, the Parliament only can remove it, not the Supreme Court. The Supreme Court job is to say any addition made to the Constitution is legally valid or not. That's all. Right. Now we have Article 14 and Article 15 to 18. We can see some sharp differences between 14 and 18 and 15 to 18. The differences are, Article 14 is called the core article, the basic article in right to equality. Why it is the core article? Because it is wider in scope. Whereas these articles, they are narrow in scope. And they are not the core articles, they are the secondary articles or subsidiary articles. They are narrow in scope. In what respect that this Article 14 is wider in scope? It is wider in scope in terms of availability. It's wider in scope in terms of availability. How it is? Because Article 14 is available to all individuals, both citizens and non-citizens. Even non-citizens enjoy this, whereas Article 15 to 18, that they are restricted in their availability. They are essentially related to the citizens. They are essentially applicable to citizens only. How? What is Article 15? The state shall not discriminate against the citizens, which means Article 15 is available only to citizens. Non-citizens don't enjoy. 16 also is available only to citizens. What is Article 17? Right against untouchability, which is a evil social practice practiced in the Indian society. Article 18, that it is about the state conferring titles and the citizens not receiving any title. Therefore, they essentially deal with the rights of the citizens or the issues dealing with the citizen. Then, this is also wider in terms of applicability. Wider in terms of applicability. Whereas these are particular classes of equality. Whereas Article 14 is general class of equality. It is called general class of equality. So why they are called 15 to 18 are called particular classes of equality? Because they are available to the individual, the citizens only in a particular situation, not under all situations. When is Article 17 available to you? When your right to social equality is violated, when you are subjected to the evil practice of untouchability. if your right to equality is violated because of the application of this the practice of untouchability, then Article 17 comes to your rescue. Under no other circumstances Article 17 is available to you. When is Article 18 comes to your rescue? When the government confers titles on one section of the population and denies it to the other section of the population, creating social inequality between the two groups. In such a situation only Article 18 comes to your rescue. What about Article 15? It comes to your rescue when the government discriminates you on certain grounds: religion, race, caste, sex, place of birth. On any other ground, if you are discriminated against by the government, Article 15 is useless. So that is why they are called particular classes of equality. Whereas Article 14 is general class of equality, which means Article 14 comes to your rescue whenever your right to principle of, wherever the principle of equality is involved. In whatever form your equality, right to equality is violated, Article 14 is available to you. So these are the major differences between them. Then further, in Indira Sahani case, the Supreme Court held that Article 14 is a part of the basic structure of the Constitution. So the Supreme Court held that Article 14 is a part of the basic structure of the Constitution. It also called 14, 19 and 21 as triumvirates of fundamental rights. So it also described these three fundamental rights as the triumvirates. Triumvirates means what? Threesome or trinity of the fundamental rights. Trinity of the fundamental rights. So these are the three most important fundamental rights according to the Supreme Court, and 14 is one of them. Right. Now the next is, what kind of right to equality Article 14 confers on us? Article 14 confers two types of right to equality. Right to equality before law and second, it also confers the right to equal protection of the laws. So right to equality before law and right to equal protection of the laws. So we will discuss these two doctrines one by one. So the first is equality before law. So as a legal concept, it originated in England. So as a legal doctrine, it originated in England, and it is called a negative concept. It is called a negative concept, equality before law. Why it is negative concept? Because essentially it means absence of privileges. Absence of privileges for any individual in the eye of law. So essentially it means the absence of privileges enjoyed by any individual in the eye of law. Or in other words, nobody enjoys any special favors from the law. That is the meaning of this. For example, before equality before law became a legal concept in England, the four sections of the English society, the royalty, the aristocracy, the clergy, that the priestly class, and the common man, they were treated differently by law. For example, if a priest and a common man had committed the same offense under similar circumstances, the law did not give them similar punishment. The law gave a stringent punishment to the common man and it gave a lenient punishment to the priest. So the law applied differently for different sections of the population, or in other words, one section of the population enjoyed certain privileges in the eye of law. With the equality before law became a legal concept, these privileges enjoyed by one section of the population had been withdrawn and the law started treating everybody equally. So that is why it is called a negative concept. And what is the meaning of, what are the other meanings of equality before law? So equality before law means three things. Take down. All persons are equal in the eye of law. All persons are equal in the eye of law, and no person is above the law of the land. And no person is above the law of the land. Then second, all persons, whether high or low, all persons, whether high or low, in rank or position, shall be subject to the ordinary law of the land. Shall be subject to the ordinary law of the land. So what does ordinary here mean? It means the law which is common to everybody. So the law is common. Now because of the second principle, if the Prime Minister of the country and the common citizen, if they commit the same offense under similar circumstances, they will be given similar punishment. The Prime Minister will not be given a lenient punishment. That is the second principle. Third one, all persons, whether high or low, in rank or position, all persons, whether high or low, in rank or position, shall be equally amenable. Shall be equally amenable to the jurisdiction of the ordinary courts of the country. Shall be equally amenable to the jurisdiction of the ordinary courts of the country. Equally amenable to the jurisdiction of the ordinary courts of the country. So ordinary courts means courts that are common to everybody. So the third principle says that no special courts can be established to try special individuals. If the Prime Minister and a common citizen, they commit offences, they will be tried before the same courts. that the government cannot establish a special court to try the Prime Minister. So the very establishment of a special court may mean some bias that is shown before towards that individual. So everybody will be punished. For example, when the Janata Party government in 1977 established a special court to try Indira Gandhi for the excesses committed during the national emergency days, the Supreme Court stated the establishment of such a special court was against equality before law. It was unconstitutional and void. The court stated you can try Indira Gandhi for the excesses committed, but before the regular courts of the country. She will go to the same Patiala House courts in Delhi if she was to be tried. So no special courts can be established to try special individuals. Then what about courts like the CBI courts? Then what about fast track courts? Then what about court martials? What about MP MLA courts? Have you heard about them? So are not they special courts? Yes, they are special courts. And the issue is special courts can be established to try special issues, but not for special individuals. For example, the Election Commission had stated in the 17th Lok Sabha, 40% of the members of the Lok Sabha, they were facing criminal charges in a court of law. Or in other words, the number of law breakers becoming lawmakers was on the increase. And the reason was that the criminal cases, they take 10 to 15 years before they get finally disposed of in the Indian courts. And for all these 10-15 years that the same person, he continues to contest election and gets elected with the muscle and money power that he can employ. So to expedite and to take up the criminal cases pending before the MPs and MLAs, current MPs, the serving MPs and MLAs in a fast track manner, the Supreme Court directed the Government of India to establish the MP MLA special courts to try cases, criminal cases pending against the current members of the parliament and the state legislature. So it is being done for a special purpose. That is allowed. You cannot establish special courts to try only a single individual. That is it. Right. So these are the principles of this, equality before law. Now, there was an English constitutional commentator called A.V. Dicey. He wrote an extensive commentary on the English constitution, and in the process he defined law. So A.V. Dicey, he made use of equality before law to define rule of law. He made use of the principles governing the equality before law to define rule of law. And mind you, A.V. Dicey did not propound rule of law. Rule of law was much older to him. He only defined and made rule of law more popular. And rule of law derives its basis, spirit from where? From equality before law. Because the rule of law is defined with the help of equality before law. And because of this, rule of law is implicit under Article 14. That is equality before law. Rule of law is not explicitly mentioned anywhere in the Constitution. So therefore, rule of law is implicitly found under equality before law. Now let us see that what is rule of law. Separately we will take it up because it is a little long topic. So rule of law originated under the English Constitution. It originated under the English Constitution. And rule of law means lex supremus. So simply it means lex supremus, rule of law. Lex means law and supremacy is supreme. The law is supreme. So in simple words, rule of law means the law is supreme. And what do you mean by the law is supreme? It means the law is the highest authority in the country. The law is the highest authority in the country, and all other authorities are subordinate to the law of the land. All authorities, including the Prime Minister, is subordinate to the law of the land. No authority is above the law. Every authority shall have to exercise its powers within the law of the land. That's the meaning of the law is supreme. According to Dicey, rule of law means be you ever so high. The law is always above you. You be the Prime Minister of the country, but the law is above you. You be the Chief Minister of a state, but the law is above you. So that's the meaning of rule of law. And the rule of law finds its application in which area? It finds its application in the administration of the country. The executive and the legislature shall have to carry on the administration of the country, the daily governance of the country in accordance with the law of the land. So it applies more prominently in the area of administration. And in the area of administration, that it is the government that is made subordinate to the rule of law. The rule of law cannot be made subordinate to the government. The government has to administer the country according to the rule of law. Now, what is A.V. Dicey's definition of rule of law? So we had seen A.V. Dicey made use of equality before law to define rule of law. So we will see the impact of EBL, equality before law, in the definition. The first is, no man shall be punished. No man shall be punished. No man shall be punished or made to suffer in body or goods except for the violation of law. No man shall be punished or made to suffer in body or goods except for the violation of the law. Except for the violation of the law. In body means that no physical punishment can be given, like lashing, amputation of the arms and legs, imprisonment. And goods, material loss, like imposition of fine, confiscation of property. So no such punishment can be given except for the violation of law. So the only ground on which you can be punished is that you have violated the law of the land, and for no other reason that you can be punished. Right, continue with the same point. Further, such a violation shall be established Such a violation shall be established in an ordinary court of the country. Such a violation shall be established in an ordinary court of the country in an ordinary legal manner. So from this point, what do you understand? It shall be established in an ordinary court of the country in an ordinary legal manner, which means the courts are common to everybody. And ordinary legal manner means the procedure, legal procedure that is followed in the courts will also be common to everyone. And the third point we derive from this is the only authority who can punish you is what? Courts. The courts only can punish you, no other authority can punish you. The executive and the legislature can only prescribe punishment, but they cannot punish you. Right. Then second and third, repetition of what we have seen already under EBL, all individuals, all individuals, whether high or low, in rank or position, whether high or low in rank or position, shall be subject to the ordinary law of the land. Shall be subject to the ordinary law of the land. Then third, all individuals, all persons, whether high or low, in rank or position, whether high or low in rank or position, shall be equally amenable to the jurisdiction of the ordinary courts of the country. Shall be equally amenable to the jurisdiction of the ordinary courts of the country. So this means what? The third point means you can sue or be sued in a court of law. You can file a case against anyone in a court of law, and you can be filed against cases by others. So this actually firmly establishes the jurisdiction of the courts over the individuals. Then the fourth is, the Constitution is the result of the fourth point. The Constitution is the result of the ordinary law of the land. The result of ordinary law of the land. So what do you mean by that? So the fourth point means the Constitution grew and developed out of the various laws that were made in the country. Or in other words, the Constitution was a result of the laws made in the country. Is it true? So in which country the Constitution grew out of the laws made by the Parliament? In England. So this statement, fourth statement, is true in case of a unwritten constitution. It is not true in case of a written constitution. Because in written constitution, the Parliament did not create the constitution. So however, this statement stands modified. This statement stands modified in its adoption in India, where it reads as the Constitution is the supreme law of the land. The Constitution is the supreme law of the land. And all other laws in order to be legally valid, shall conform to the Constitution. So this is the fourth statement in India. In order to be legally valid, shall conform to the Constitution. So now what is the importance of rule of law? Now listen for a moment. So before rule of law became a legal concept, what was the basis of administration? How the administration was carried on? Before rule of law became a legal concept, the basis of administration was rex lex. Rex means king, lex means law. The king was law. The law was not the king, but the king was the law. But after the adoption of rule of law, how the basis of administration has changed? It has changed to lex rex. That is, law is king. So this is the first importance of rule of law. It fundamentally changed the basis of administration. So you take down that before the rule of law became a legal concept, the basis of administration was rex lex. The basis of administration was rex lex, or the king was law. But after its adoption as a legal concept, the basis of administration has changed to lex rex. So this is the first importance of rule of law. The second importance of rule of law is, according to Harold Lusky, a political philosopher, rule of law is essential for the functioning of a democracy. So rule of law is essential for the functioning of a democracy. No democracy can function without rule of law. Then the third importance is, the Supreme Court has recognized it as part of basic structure of the Constitution. So in Kashwan the Bharati case, the Supreme Court recognized rule of law as a part of the basic structure. So it's one of the pillars on which the constitutional edifice has been built. It's one of the fundamental values of the Constitution. Then the fourth is, the Constitution imposes the duty on the Supreme Court and the High Courts. The Constitution imposes the duty on the Supreme Court and the High Courts to protect the rule of law, So the highest kind of protection, duty on the Supreme Court and the High Courts to protect the rule of law by conferring on them the writ jurisdiction. By conferring on the Supreme Court and the High Courts the writ jurisdiction. So it's one of the important components of the Constitution. So the last part is exceptions to rule of law. So are there circumstances where rule of law does not apply? So general rule we have seen so far. Now we will see the exceptions. So exceptions are available under three heads. The one is under Article 361. So Article 361 talks about the exceptions given to the President and the Governor of a state, not for any other authority. So this exception under Article 361 is not given to the Vice President, not to the judges, not to the ministers, but only to the President and Governor of a state. Right. The first exception, the President or Governor of a state, the President or the Governor of a state is not answerable to a court of law, or no, is not answerable to a court of law. Court of law with regard to his executive functions. With regard to the discharge of his executive functions. With regard to the discharge of his executive functions. So whatever executive functions taken in the name of the President or the Governor is not answerable. So being a parliamentary form of government, all the executive decisions of the union government are taken in the name of the President. You will be appointed as an IAS officer tomorrow in the name of the President. But who takes these decisions? It is the Council of Ministers that takes. Therefore, you can bring a legal action only against the Council of Ministers with regard to the executive decisions that are taken, but not against the President himself. So that's the reason. Then the second is, no criminal proceedings whatsoever. No criminal proceedings whatsoever can be instituted or continued against the President or the Governor of a state in a court of state during his term of office. During his term of office. So long as the President occupies his office, no criminal proceedings can be instituted against him in a court of law. Even if he commits a crime, he cannot be arrested, he cannot be charge sheeted, he cannot be brought before a court of law. Under Article 361, the President or the Governor enjoys complete immunity from the criminal jurisdiction of the courts. But this is available only so long as he occupies that office during the term of office. Once he steps down, for example, because of the crime committed by him, if he is impeached by the Parliament, or he resigns, or he completes his 5-year term. So once he steps down from his office, he will be tried for the crime committed by him earlier. It's not that he will go completely scot-free, but he will be exempted only so long as he occupies this office. So this suggests that the exemption is given with regard to the respect shown to the office but not to the individual who occupies that office. Right. Then third, what happens in case of civil proceedings? Listen for a moment. Suppose if the president commits a civil wrong, for example, that he drives rashly and breaks the leg of a pedestrian. Now the president is bound to pay compensation to the pedestrian for the injuries suffered by him. But under Article 361, the pedestrian cannot straight away go to a civil court, file a compensation petition claiming relief from the president. Instead, Article 361 says the pedestrian has to issue a notice, 2-month notice to the president seeking compensation for the injuries suffered by him. And if the president makes good the compensation within this 2-month period, no civil proceedings claiming compensation can be filed against him. However, if the president does not make good the compensation within this 2 months period, then on the expiry of the 2-month period, the pedestrian can file a civil petition before a court of law. So there is a limitation in terms of time. Take down. Third point, no civil proceedings. No civil proceedings in which relief is claimed, can be filed against the president or the governor of a state, except after the expiry of a 2-month notice, issued on him. Yes? Except issued on him. Right, the next class of exceptions that under Article 105 and 194. So 105 confers the immunities and privileges on the members of the parliament, and 194 confers the same privileges and immunities on the member of a state legislature. And you know that whatever that a member of the parliament speaks in the house, reveals documents in the house, and the vote that he gives in the house is not answerable to the courts. He is answerable only to the house to which he belongs. Right, take down fourth one. A member of parliament, an MP or MLA, a member of parliament or member of legislature, is not answerable to a court of law. Is not answerable to a court of law for whatever he has spoken, revealed, or vote given by him in the house. Revealed or vote given by him in the house. or the committees thereof. Right. The last one under international law. Now a lot of diplomats, they are posted in the country, foreign diplomats who are posted in India. Then a lot of the dignitaries, they visit India. So the visiting heads of state, heads of government, ministers, so they are not subject to local jurisdiction. They are not subject to the jurisdiction of the local courts. So under the Vienna Convention on Diplomatic Relations, 1961. So these exceptions are provided to them. Right. So the fifth point, the visiting heads of state heads of government, other officials, foreign diplomats who are posted, and foreign diplomats who are posted in the country, foreign diplomats who are posted in the country are not subject to the jurisdiction of the local courts. Are not subject to the jurisdiction of the local courts. So they are exempted. But if they somehow submit themselves to the jurisdiction, they will be bound. There was a very interesting case held a few years ago. So there was the Italian ship, the marine ship that was traveling close to the Kerala coast, and two marines, Italian marines, they shot and killed two fishermen within the territorial waters of India. They were arrested by the Indian government, and those two Italians were tried for the criminal charge of murder in the Indian courts. Then they were held in prison. Subsequently, the elections were held to the Parliament of Italy. So these two persons, they wanted to go back and participate in the democratic process of their country. And on the undertaking given by the Italian ambassador to India to the Supreme Court allowed them to go back. So they went back, and after 2 months they came back and continued to stand trial in India. Subsequently, that for Christmas celebrations, they wanted to be with the family. This time also, on the undertaking given by the Italian ambassador, that the Indian government, the Supreme Court allowed them. But this time they refused to come back. Immediately, the Supreme Court directed the Indian government not to allow the Italian ambassador to leave India. And they promptly came back, and finally it was all settled on the basis of mutual factor between the two governments. The justification the Supreme Court stated was, when the Italian ambassador gave a undertaking to the Supreme Court, he agreed to come under the jurisdiction of the Supreme Court within the limits. For the return of the accused, the ambassador was the guarantor. So to that extent, he had submitted himself to the jurisdiction, therefore the Vienna Convention will not apply. Now what happens that if such a person commits a crime in India. For example, that when Myanmar was called Burma, the Burmese High Commissioner posted in Colombo, Sri Lanka, he murdered his wife in Sri Lanka in the diplomatic enclave. And the Sri Lankan government could not arrest him because of the Vienna Convention. He was declared as persona non grata. That is unwanted person, and asked him to leave the country within 24 hours. As soon as he reached his home country, Burma, he was arrested by the Burmese government and he was tried for murder within the Burmese law. So it's not that such persons who commit crimes say, diplomatic personnel in another country will go scot-free. They will be tried in their home country according to the home law. So they will be declared as persona non grata, that is unwanted persons. Leave the country within 24 hours. Right, so this completes the discussion on rule of law. So the next is rule by law. How rule by law is different from rule of law? So we know what is rule of law. Rule of law, wherever rule of law prevails in a country, it is presumed that the law of the land that is used for the administration of the country is not only fair, but it is just and reasonable. It is the meaning of rule of law. And the law of the land that is used to administer the country is not only legally correct, but it is also morally valid. It carries both legal and moral validity. And the purpose of rule of law is to render justice to everybody in the country without any discrimination. And such a law is known as droit justum. I will give you some notes. That is, droit means rule, and here it is just law. Whereas rule by law means that the law of the land which is used to administer the country may not be fair, just and reasonable to everybody. The law may be legally valid because it was enacted by a legally established parliament, but it may not be morally correct. The purpose of the rule by law is not to render justice to everybody, but to confer certain privileges on one section of the population and deny the same privileges for the other sections of the population. Therefore, rule by law, it uses the law as an instrument of oppression. It oppresses one section of the population and while conferring privileges on the other sections. And such a system is known as rule by law. For example, the apartheid rule in South Africa between 1920 and 90 was an example of rule by law. The apartheid system under which the racial discrimination was officially carried on by the administration on the basis of the color of the skin, that only the 19% of the whites alone were recognized as the citizens of South Africa. We had seen. And they alone were given the voting rights. They alone were allowed to occupy high public offices. And the other 81% of the non-white population was recognized as the nationals of South Africa, but not as citizens of South Africa. They did not have voting right, and they were not allowed to represent the country outside South Africa. And the law was used as an instrument of oppression to keep the 81% of the population down. So therefore it was rule of law, rule by law. The Taliban rule in Afghanistan today is also an example of rule by law because it denies equal opportunities to women and minorities. The law itself denies. So they are all examples of rule by law. Right, take down. Rule of law presupposes that the law of the land presuppose rule of law. Rule of law presupposes that the law of the land that is used to administer the country, the law of the land that is used to administer the country is fair, just and reasonable. Is fair, just and reasonable. It is not only legally correct but morally valid. Such a law is not only legally correct but morally valid. Its purpose is to render justice to all. Its purpose is to render justice to all. Such a legal system is called droit justum. Droit justum or just law. Right. Next paragraph. On the other hand, rule by law means the law of the land that is used to administer the country, may not be fair, just and reasonable. May not be fair, just and reasonable. Such a law may be legally valid. Such a law may be legally valid, but not morally correct. But not morally correct. Its purpose is not to render justice to all. Its purpose is not to render justice to all, but to confer privileges, on one section of the population and deny the same to the other sections. Thus, the law of the land may be used as an instrument of oppression. Is used as an instrument of oppression. Such a legal system is called droit injustum. Such a legal system is called droit injustum, that is unjust law. injustum, that is unjust law. Examples: the British colonial administration in India, the British colonial administration in India, the apartheid rule in South Africa, the apartheid rule in South Africa, and the Taliban rule in Afghanistan. Are examples of this. Is rule of law the same as procedure established by law? No. They are different things. Procedure established by law and due process of law, they mean that to ensure that the application of law is fair, just and reasonable. They are two different issues. We will discuss about that under Article 21. Right, so equality before law is over. So I think we will take it up in the next class because I have to explain. You are tired, so I will take it in the next class. So because I would like you to listen first, understand the concept, and then I will give you a short dictation. I will take it up in the next class. Thank you.